Good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. Today is January the 6th, 2022. This is our call we hold every other Thursday. The call does not create an attorney-client relationship, and the information is being presented as is with no guarantees. You would be subject to the same disclaimers that you heard when you called in. Before we get started, I just want to make sure everybody can hear me okay, so let's just do a quick check.
The conference is now in conversation mode.
Can you all hear me, guys? Everybody can hear me? Say
Yes,
right.
Excellent, thank you.
The conference is now in presentation mode.
First of all, a very happy new year to all of you. I have today only one frequently asked questions, which I'll deal with first, and then we'll deal with the other 13 posted questions, any follow-up questions on top of that. And if we have time remaining in the hour that we have today, we will deal with new questions. The first question that's a frequently asked question is this. I have an approved I-140 from employer A. Currently, I'm working in my home country for employer B. Priority date is now current. Can I go for consular processing for an I-140 that has been approved from employer A, but an offer letter from employer B? The answer is no, you cannot. First of all, whether you are inside the United States or outside the United States, you cannot use the I-140 approved through one employer to file a 485 through another employer. That cannot be done. You can carry the priority date and redo the green card through the new employer. But if you want to just carry over the I-140 and file 485 or consular processing, that does not work. However, the priority date in all likelihood is your property and it can be transposed to another green card. Press *5 on your phone if you have a follow-up question on this. Press *5 if you have a follow-up question. Okay, let's go on to the first posted question after that. Abhishek says, will changing my job title and duties affect my I-140? I have an approved I-140 under EB2 from employer A with more than 180 days priority date 2019. Moved to employer B. They will be starting new I-140 in 2022. Job duties and code are different from employer to employer B. I'm going from being a senior business analyst, from sales engineer to a senior business analyst. Will there be a problem in porting priority date? No problem at all. Remember, to port the priority date, the professions don't have to be same or similar. For example, I always give my own example. I have a degree in biology and chemistry, and I have several degrees in law. If I wanted to pursue my career as a biologist or as a chemist, I could do that and still get the green card priority date that I had obtained through the I-140 approval as a lawyer. So you could actually completely change career tracks and you would still be entitled to carry your priority date. And that's an easy one. This is quite well settled. So the priority date transfer does not require you to stay in the same profession. Press *5 if you have a follow-up question. No new questions. Any follow-up question on this? Press *5. Okay, let's go on to the next posted question. This is from Ronak. His application to replace a permanent resident card due to a typographical error is pending and he wants to travel outside the USA. He says, Happy New Year, sir. Happy New Year to you as well. I recently immigrated to the US on a spouse green card basis. I've got the actual green card, but it had a typo. So you applied for a replacement. I've been waiting for the new green card since June 2021. So there was a discrepancy in the date. What expiration date is to be used for the outside country temporary visit? First of all, make sure that you get your passport stamped. Your passport should be stamped for travel. Normally, many of the government notices now contain an endorsement that says you can use this notice to travel for X or X number of years. So look at the receipt that came with your replacement application. That receipt should tell you whether you can travel on that receipt. If not, you need to take an InfoPass appointment, go to the local sub-office of the USCIS, show them the receipt of the pending replacement. They will stamp your passport, and the stamp will say something like this. It will say, processed for I-551, which is green card, processed for I-551, temporary proof of permanent residence. If you get that stamp on your passport, you can travel with that as though you had your green card. Of course, you need your passport to be stamped. You need to bring it in. If, on the other hand, the receipt says this is evidence, temporary evidence of green card can be used to travel, then you just need that receipt and your passport, and you should be able to travel. Okay, so that's what you should be doing. *5 if you have a follow-up question on this. Press *5. Okay, 1 second, Ronak. Okay, I can hear you, sir. Go ahead, please.
Happy New Year, Rajiv, sir.
Happy New Year, sir.
So, sir, I did the the biometric things are done, but I did not get any receipt or any document that says like I can travel. And because of that reason, I tried to contact USCIS regarding this. So what they told me is that you have a stamp, and that stamp has expiry for 1 year. So from the date you came to United States, we put a stamp on your actually printed stamp, and you can travel up to 1 year, but it depends on the border agency, and it depends. So that's why I'm still not clear whether that stamp will be valid or not.
Easiest thing to do is just take an InfoPass appointment and go to the USCIS and tell them to just put a stamp for 2 years, if they will. If they won't and say this stamp is good, then the next step is to go to the local Customs and Border Protection. Okay, you can go to cbp.gov and look for their offices. Go to one of their offices, or you can email them, even call them. They respond to calls and emails. Tell them this is my situation, what do I need to do? And the good news is, once you have something from CBP, they are the people you deal with when you travel back to the United States. So it's really the CBP's call more than anybody else's. Okay?
Okay. And I think the call that I think it wasn't USCIS, it was CBP. So whom I called regarding that. But there was like 2 dates printed on the paper.
Yeah, what I told you, sir, is go to the USCIS first.
Yeah.
Okay?
Sure, yeah.
Good luck.
Yeah, thank you.
You're welcome. Bye-bye.
Thank you.
Bye. Okay, on to the next posted question. So EB2 and I-485 processing and job change after I-140 approval. Prabhu says, I'm currently working for an employer on H-1B. Recently changed from H-4EAD to H-1B, okay? In the past, I worked on L-1B. Based upon that, my previous employer had filed I-140 through consular processing. My I-140 was approved and the priority date is November 2013, EB2. What are my next options? Below are my details. Past L1B, So questions are, can I start I-485 with my current employer? I just answered that question. In another context, you cannot file an I-485 through a new employer where the I-140 was approved through an old employer. You have to start the green card all over again. And if your I-140 was not revoked for at least 1 day after 2017, January 17th, 2017, you will then be able to carry your priority date. Okay, so you have to double check your I-140 should not have been revoked before January 17th, 2017. Okay. So you can only port then. You cannot do any green card processing through a new employer based upon an old I-140. Okay. Star 5 if you have a follow-up question. So the priority date can be ported if, yeah, okay, here we go. Let's see, what is the question? Area code 678. Go ahead, please.
Hi, Rajiv. It's Prabhu here.
Mm-hmm.
So the question is, since my old I-140 processed through the consular processing, will it make any difference? Because currently my employer is started with green card processing.
No difference. No difference, Prabhu. No problem. Same answers.
When I'm porting the I-140 also no issues, and
no issues.
485 when I'm filing with the new, no issues, right?
No issues. Only one thing, make sure that I-140 was not revoked before January 17th, 2017. You're good.
Yeah, so as of now, I got the I-140 approval, and the status when I look at online portal, it says it's not date revoked.
So chances are you're fine. You can carry your priority date forward. No issue. Okay?
Okay. Yeah, thanks, Raj.
You're welcome. Good luck. Okay, next question. Time taken to get residency after marrying a US citizen. Assuming I were to start applying for US permanent residency in Q1 of 2022 post my marriage, how long does it take to get permanent residency in the United States? What would be the cost if I were to take the services of your law firm? I'm born in India, moved to Canada in 2016, working on TN visa. I'm getting married this time. Spouse is a US permanent resident, born in India. So, a happy new year to you as well. First of all, there are two issues here. One is the priority date current? So the priority date for spouses of green card holders has been running current for a while. Assuming it stays current, then comes the second part, which is the processing time, and that can be substantial. But the good news is, since you are in the United States on TN, you can apply for your I-485 and the I-130 right here. In about 10-11 months, you will get employment authorization as well as advanced parole. Using that, you can travel. Do not travel on your TN because travel back into the United States can be refused. TN is not a dual intent visa. Okay. So how long will it take? It doesn't really matter. It depends a lot upon the local processing times because 485, which is the application you will file, are being processed locally. And they will be ultimately, you'll go through an interview. And the times are as wide as anywhere from 1 to 3.5 years. But like I said, the good news is you've got your employment authorization. With that, you can start your own business. You can change jobs. You can choose not to work. You can choose to completely change professions. Any of that is possible. Star 5, if you have a follow-up question. Star 5. Oh, area code 919. You are from the North Carolinas? North or South Carolina?
Yes.
Okay, 1 second.
North Carolina, Rajiv.
Yeah, let me tell you where our fees are. So, couple of things I wanted to point out. When you go to our homepage, our fees and my blog is right on top. So you click on the fees. It's all being recorded. Click on the fees. Actually, give me 1 second. The fees is right here. So you click on that, and that contains all our fees, including the expenses, filing fees, etc. Okay. So we just go to immigration.com. Yeah, go ahead. Go ahead with your question.
Sure. One quick question. You mentioned about getting the EAD. So how long does it take to get an EAD if I'm having a U.S. permanent resident?
That's an uncomfortable question to answer because the times are so variable. But I would say not before 8-9 months.
8-9 months. So within a year period or so, it's possible.
Yes, it is highly likely. Highly possible.
Okay.
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 Good luck,
Thank
sir.
you very much, Rajiv.
You're welcome. Good luck and congratulations on your marriage.
Thanks. Thanks very much.
Bye-bye.
Happy New Year.
Happy New Year.
Bye.
Bye-bye. Okay, so next question, posted question is, this is about J. Dhulapati, AC-21 regulations and I-140 withdrawal and revocation. So you want to know about AC-21 rules. My I-485 is pending more than 180 days. My I-140 is approved and it has only been 120 days after receiving approval. So you are already covered by AC-21, fully protected. And I've given this example many times before. I'll give it again. The law says your I-140 must be approved and your 485 must have been pending 180 days. What does that mean? Let's say we filed your I-140 and 485 together on January 1st. Okay. So just to make the math easier. And let's say you got I-140 approval in May, which is about 5 months into the process. About 150 days. Okay. If you filed the I-140, 485 together, you become AC-21 protected in 30 more days. Why? Because your I-140 is approved and in 30 more days, your I-485 would have been pending 180 days. So you don't have to wait 180 days after the I-140 is approved. Only requirement is I-140 is approved and 485 has been pending 180 days. So let's look at your situation. My I-485 is pending more than 180 days. That's the key criterion. I-140 is approved, good enough, you are covered. If the employer revokes the I-140, you are not affected. You are completely covered by portability. Star 5, if you have a follow-up question on this. Star 5. Area code 248, I don't know where that is. Where are you calling from? Area code 248.
Hi, Mr. Rajiv. This is Dhulapati here. I'm basically the area code is Detroit area.
Okay.
So the situation is I got laid off recently and I'm on this H1B 60-day grace period and I'm still waiting for the EAD card.
Okay.
And if I go to adjustment of status, what happens to my wife who is currently working on H4 EAD?
Her H4 is no longer good because if you don't have H1, she doesn't have H4. If she doesn't have H4, she doesn't have H4 EAD. That's the way I understand it so far. There is no other policy statement. So she will have to wait to receive her EAD under green card to continue working again. Okay?
Okay. Got it. Understood. And one last thing. During the 60-day grace period, do you think a H4 EAD applicant can work still on the 60-day grace period?
Once they file their application, they can.
Okay. Got
All
it.
right.
Okay. Thank you so much,
You're welcome.
Mr. Rajiv.
Good luck, sir.
Bye.
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 Okay. So the next question we have is green card holder working for multiple companies at the same time. Mr. or Ms. Reddy says, this is for a friend of mine. They've got their green card, working for the same company who sponsored the green card. Now he wants to work as a consultant for another company. He plans to work 40 hours per week for the new consultant company also. Both jobs are remote. Is it legal for him to work on 2 different companies? Absolutely. He's got his green card. Can the green card sponsoring employer cancel his green card? No. Any issue during citizenship phase? I don't see any issue here. Star 5, if you have a follow-up question. Star 5. Okay. There is a follow-up question. Let's see. Area code 541. Where are you calling from, 541?
Yes. Hi, Rajiv. Yeah, this is Reddy. Yeah, I'm calling from Portland, Oregon.
Okay, sir. Go ahead, Mr. Reddy.
Yeah. Yeah. This is one of my colleagues. So he asked me to put this question
Sure.
in the forum.
Sure.
So the same thing. So his main criteria is, okay, since he's working remote, working from home. So he said, he could able to manage multiple jobs.
Yeah.
So that I think he wanted to make sure, okay, the employer is not canceling GC if employer come to know that
No.
he's working.
I do not see any risk of that. Okay.
Okay. Yeah. Thank you so much, Rajiv.
You're welcome. Good luck.
Thank you.
Next question. So here is a question from Shri, and this is a very common situation actually. Recently received my employment-based green card. My wife was outside the country. I filed I-824 and that is taking forever, 2 years plus. But you know what, Shri? Have you considered another option? How about if you applied for her I-130 at the same time as the spouse of a green card holder? And that might be considerably shorter time. Okay. And in addition to that, can you also take a reentry permit and go live with her? I think so. I don't see why not. Just remember, when it is close for her to get her green card, when she gets an interview, you should either already be back in the US or you should be in the process of coming back to the US. That's one of the requirements of the affidavit of support. Okay. But you can do that. I would want you to just talk with your lawyers in detail before you plan anything. But at least conceptually, I don't see any problem with this. And I would recommend that you file an I-130 also for her. Whichever green card comes first, she gets it. *5. If you have a follow-up question on this, *5. Okay. Can 797A be made a valid document for re-entry? Not without a visa. You need a visa. So you can't enter the United States only based upon only your approval. If you're a Canadian citizen, yes. But for everybody else in the world, you need a visa stamp. Okay. *5. If you have a follow-up question, can you as a group petition the Department of Homeland Security? You can try, but I don't think they have the power to do it. I think it may be illegal for them to do so. Okay, *5, if you have a follow-up question on this. Yeah, see, some changes in the law can only be brought about by Congress, not by the agencies. Oh, there is a follow-up question. Let's see. This is from area code 541. 541, where are you calling from?
Sorry, Rajiv. This is regarding the multiple employer green card question. Can I ask now?
Try not to do that. I consider that very disconcerting because I got to keep jumping from one question to another. Make an exception this time, but let's not do that as a matter of routine. What is the question?
Yeah, okay. So the question, his concern is, so can the current employer know that, he's working?
Yeah, I don't know. I don't know the answer to that question. Under immigration law, he cannot. But can he, if he has other sources, I do not know. But immigration law does not allow him to find out. Okay.
Okay. Yeah. Thank you, Rajiv.
You're welcome.
Thank you.
Okay. So then, can I apply from Santosh Menon? Can I apply for H-1B visa while on OPT? Yeah, that's what the whole world does. This one is for my son. He's currently on OPT. F1 visa expired. His H-1B was approved for Consular. Since he intends to complete his OPT before activating H-1B, can he renew his F1 visa while on OPT when he has an unstamped H-1B? And the answer is yes, absolutely. I don't see any law that stops him from doing that. So he can then activate his H-1B later on when he's done with his OPT. I don't see any problem with that. *5, if you have a follow-up question. *5. Okay. Gautam says, F1 STEM OPT work permissions. Happy New Year, Gautam, for you also, sir. I'm on F1 visa, currently pursuing my master's in electronics and computer engineering. And you want to go into management consulting with McKinsey, Bain, BCG. This would land me into visa problems. Yes. Is there any way I can get around this problem? Well, if you were providing consulting in the engineering work, for example, as a process engineer or somebody whose work requires a degree in electronics and computer engineering, only then. Can I work in management consulting as ECE Masters? I guess that is electronics and computer engineering. Only if the job requires that degree if you want to get an H-1B. Star 5, if you have a follow-up question on this. Star 5. Okay. Let's go on to the next question. So this is entering the United States on a visitor visa with an approved I-130 and consular processing. My parents have their I-130 approval. We haven't started their consular processing yet. Can they travel to the US on a visitor visa? And the answer is yes, but the CBP at the airport can say, well, you have a green card pending, you should go back. Although I have not known them to do that. I don't know a single case. So here's what you can do to avoid the problem, Naveen. What you can do is you can clear immigration in Abu Dhabi. That way they will know in Abu Dhabi whether they can enter USA or not. So take a flight that clears immigration in Abu Dhabi, and if they are denied entry, they just have to fly back a couple of hours back to India. And I don't think they'll be denied entry. That's my guess. Technically they can be. As a practical matter, they shouldn't. Star 5, if you have a follow-up question. Star 5. Okay. So guys, we're going to have a lot of time for new questions. I was able to go through the questions very quickly. So prevailing wages processing timeline. My prevailing wage is filed in first week. Prevailing wage takes 15 months? I don't think so. I think that's an exaggeration. I was talking with my team yesterday and I thought they said about 5 months. You can double check it, but in my view, it should take about 5 months or so. I hope I'm not wrong. How many days a perm is taking? Well, who can tell you how much time it's taking? It's too many variables. Again, these are questions that are impossible to answer. But the prevailing wage seems to be too long. It's not 15 months. I hope not. But if you want to double check this, you can send a mail to Sumanji, suman@immigration.com at our office. And just say that how much time is it taking approximately for prevailing wages. She probably won't be able to give you a good idea of time taken for perm, but prevailing wages should be fairly straightforward. Star 5, if you have a follow-up question. Star 5. Okay. So primary visa holder entering the US on advance parole and the dependent on employment authorization, you can't enter on employment authorization. You enter on advance parole only. I filed my AOS application, downgrade. I have 2 questions. I'm planning to travel to India and thinking of entering back in USA on advance parole, and primary is planning to work for sponsored employer on H1. Dependent will use EAD for employment. Well, I have always had a problem understanding why some lawyers say that you cannot move 485s just because you use the EAD. I can understand why you cannot file a new 485, but moving 485 to another I-140 should be possible, as far as I know, even if you have traveled back on advance parole. If I move to a different location in same company, well, in that case, you would have to file a 485J, and that would be the smart thing to do, because that means you are using AC-21 portability if the job location is more than 50 miles away, approximately. But that's the question best answered by your lawyers, whether they need to use AC-21 portability or not. I certainly think that you do. *5 if you have a follow-up question. *5. But that's not a big deal. AC-21 portability is a simple enough and tried and tested enough method. Okay, guys, I'm done with the posted question. Anybody who has any question, press *5. Anyone who has any question, press *5. Let me see how many I can answer. Okay, let's count how many questions we have. Well, we have a lot of questions. 6 questions. Okay, let's see how many we can get through. Start with area code 216. Area code 216, where are you calling from?
Yes, from Cleveland, Ohio.
Yes, go ahead, please.
Yeah, hello, Mr. Rajiv. I have a question. Like currently, I'm on my H4 without EAD.
Okay.
So, and I will start my school in July.
Okay.
So I would like to transfer my H4 to F1 visa.
Okay.
So that I will do in April once I will get my I-20. So my question is, once I might file change of status from H4 to F1, then after my H4 is expiring on August 2022. So do I need to extend my H4?
The answer to that is, I don't believe you do. They have changed the rules recently. You can double check with your DSO. But because you are going from H4 to F1, 2 things are clear. You can continue going to school even when the F1 is pending and even after the H4 is expired. So the answer is, you should not have to extend your H4. Should you do it anyway? No, I don't think so, because it creates a conflict with your F1. So that's what I believe. You can double check with your DSO. Okay?
Okay, and one more question, like about biometrics. There are changes like biometric rules, so I'm not sure that when I will transfer my H4 to F1, do I need to do a biometric?
I have no idea.
Not?
I have no clue what the procedures are. That's somebody, our team handles those details. I don't know the answer to that question. Sorry. Okay.
Okay, and one more question.
You're gonna have to be a little considerate of other people also. So make it really quick. This is the last question I'm answering for you.
Okay, if I go from H4 to F1, though, so it will impact on my getting a OPT, anything like that?
If you are on H4, you can't get OPT. You have to be on F1 to get OPT. Okay?
No, like my question is, I will change the transfer of status H4 to F1, so it will impact once I will get F1, then getting a OPT.
I don't know. I don't understand that question. The answer is, you cannot get an OPT if you are on H4. But if you are on F1, under certain rules, you'll get different kinds of OPT. And the rules are different for different kinds of OPT. So yes, having an F1 makes it easier for you to get OPT. All right?
Okay, thank you.
You're welcome. Area code 801. Where are you calling from? Oh.
Hi, Rajiv. I'm calling from Salt Lake City, Utah. Here is my situation. My girlfriend, she's currently in India. One of her relatives are inviting her to come to California, USA, based on the visitor visa B1. In future, if we get married, she will be my dependent on H4 visa.
Okay.
Will there be any problem during the H4 visa interview, because she has come on she has come to the US previously on the B1 visa?
Not at all. No problem.
Even if our H4 visa interview is going to be in like the next 1 year, is it not going to be a problem?
No issue.
Okay, cool.
All right.
Thank you so much.
You're welcome. Good luck. Area code 512. Go ahead, please. Where are you calling from? Area code 512.
Hello, Rajiv sir. The code is Austin, but I'm in Houston, Texas right now.
All right.
I had a question about H-1B, change of employer.
Yes.
So I'm working for a current employer, and I will be putting my notice period very soon. I just want to make sure, should the last day of my notice period be on the same day as the start date of the new employer, or how does that transition work?
Okay.
Meaning,
so
what is a safe transition so that I don't violate any immigration laws?
It isn't that difficult. Is your second H1 already approved, or is it filed?
It is filed. It is under premium processing, so I should know that within a week or so.
Okay. So first of all, I would give notice only if I hear about approval. That's the smart thing to do, unless there's something else. Once you hear about the approval, you can give a 1 week notice, 2 week notice, 1 month notice. It's your call. Because just because the second case is approved does not affect your first case. So once the notice is over.
No. So what I was, sorry sir, what I was trying to see was, are gaps allowed between my last date and my current employer versus
Absolutely. Once the second case is filed, you can wait as long as the approval. Okay. So let's say that let's take another scenario. Your second case is approved. You gave a 2 week notice, and then you want to stay at home for a couple of weeks before you join. That's okay too.
Okay.
Right. So there can be
on the other side, can an overlap exist? Meaning, let's just say my start date is on a Friday in February, which is exactly Friday.
Okay.
And if the notice period ends on Monday, is that an issue? Because there will be that double pay period between Friday and Monday.
You can't work for two employers simultaneously unless you have concurrent approval.
Got it.
You can't overlap like that. No.
Got it.
Okay.
Can't overlap. Okay. That's the question. Thank you, Rajiv.
You're welcome. Good luck, sir. Good luck.
Yeah. Thank you.
Area code 614. Where are you calling from? Area code 614.
Hello, Rajiv ji. I'm calling from Detroit metro area.
Yes, sir.
Yeah. So I'm currently in an automotive company on H1B with I-140 approved in 2018. No 485 filed. I have a job offer from an automotive supplier, they are a supplier, who has a presence in Ontario, Canada, as well as physical presence in the Detroit metro area on the US side. Now, my situation is that I can either transfer over my H1B, or I have a Canadian PR, so they can just employ me on the Ontario side without any sponsorship. However, because the customer accounts are still on the US side, I would have to come and go, to this. Obviously, as an application manager, I have to come to the customer side, like 20% time. So in that situation, which would be the better route, just to transfer H1B, or go for the Canadian side and then after 1 year try for the EB1C route, since I would be in a managerial role?
Well, if you are in a managerial or executive role, remember that definition is not your ordinary definition. It has some very legal, intricate nuances. Make sure that your immigration lawyers have reviewed your proposed job that you'll be doing in Canada and your proposed job that you'll be doing in USA when you return. In such a case, I would definitely want you to go for EB1C, no question in my mind about that. We've done this 100 times before. It has always worked out. Just make sure that you plan ahead and your job descriptions are approved. Okay?
Okay. And then in that period when I'm working from Canada as a Canadian employee of the company, am I allowed to come to the US at all, or?
Well, there are a couple of problems. There are a couple of problems. If you are in the US for a day, then you have to spend an extra day outside USA. Now it's not 366 days. Now it's 367 days. If you are in USA for 20 days, you have to spend an extra 20 days outside. Can you come?
Okay, so it just postpones accordingly.
Right.
I see.
But can you come? That depends upon the nature of your visit. So if you are coming, for example, you are in automotive engineering. Let's say you are in robotics, and you are designing a robotic arm sitting in Canada. The project is being performed in Canada, and you've only come to shake hands and show a demo of your prototype to the client. That's an appropriate use for a business visa, which for Canadians is simple. You just you're an immigrant, so you have to get a B1 visa to come to the United States.
Right, B1 visa, right?
Right.
Yeah. So in that 1 year, if I have to come, I'll have to come on B1. I cannot come on an L1 visa, right?
L1 doesn't kick in until 1 year. 366 days are over. So L1 is not possible until.
Oh, I see.
Yeah.
Oh, L1 is not possible to begin with anyway. Okay.
No.
So in that 1 year, it has to be a B1 visa for whatever days I have to come in to the customer site, right?
That is correct.
Okay, I see, I understand. Then I'll discuss with the lawyers accordingly and see which is the best route. Otherwise, I can always transfer over my H-1B and work in the US and live on the winter side in Canada.
Yeah,
anyway,
you can do the daily commuting thing, yes.
Yeah, the daily commuter thing. Yeah, all right. Sounds good. Thank you so much.
Good luck.
Yeah.
Okay, area code 862. 862, where are you calling from?
Yeah, hi. I'm calling from New Jersey, US. So my I-140 just got approved. I'm from a company, like Indian company, and working on H-1B. So my I-140 just got approved. My question is like, after how many days I can change employer if I want? Because if I want to switch to a company which is better, and also I am having future plans of bringing my spouse here. He's also applying for MBA for Canada on GMAT score and also in US. So I'm a little bit confused that whether it will be a good option to go for him for Canada or coming here for EAD, because here H-1B is whole luck, but in Canada at least within work permit he can get a PR and we can plan to shift there. So,
okay, now there's a bunch of confused questions here. Some I can answer, some I cannot. I don't know anything about Canadian laws, so I will not comment about that. The question that you asked me is, when can I leave? I-140 is approved. So if you want the full benefit of the I-140, you can leave, and as long as the I-140 is not revoked for 180 days, you carry all the benefits. But if you leave before 180 days after approval, the employer can revoke the I-140, and if they revoke, they cannot take away your priority date, but they can take away your right to get H-1B extensions beyond 6 years with any employer based upon that I-140. Okay, so 180 days is the full benefit date after approval. Okay,
got it.
What else can I help you with?
Yeah, so I-140 EAD, how is the job market here? Like if I bring
I
my
don't
spouse
know.
here,
No comment. No comments. I'm a lawyer, not a headhunter.
No comment?
I have no idea. Okay.
Okay, no problem.
Good luck.
Okay, thank you. Thank you, that's it.
Bye.
Yeah, thank you. Bye-bye.
Okay, let's see. Area code 404. Go ahead, please. 404. 404, where are you calling from? Area code 404.
Oh yeah, I'm calling from Atlanta.
All
right. Actually, I did downgrade last year in October 2020. But meanwhile, I got a NVC letter. So NVC letter, but we never selected the consular processing in the I-40 application, my old application, new application. Actually, so I'm not sure what should I do with that NVC letter.
You need to contact the USCIS. First of all, make sure that I-140 was not marked for consular processing. When you filed the I-140, you have to mark it for adjustment of status or consular processing. So make sure that was not marked for consular processing. If it was, you need to stop that process. Okay, you can let NVC know that we are going with 485. So begin your investigation.
In that letter,
Go ahead.
Okay, sure, yeah.
So begin your. Let me finish my sentence then. Let me finish my thought. So begin by looking at the I-140. If it was incorrectly marked, you have to inform the NVC that we are doing 485. You don't have to do anything else. We are doing adjustment of status. That's enough. but it was marked correctly, and USCIS still sent it to NVC. Open a service ticket with USCIS and say, why did you send my case for NVC processing? I am with you, 485. Okay.
Okay.
Sorry, I lost you. Did you say something? I think I lost audio for him. Okay, area code 813. Let's see, 813. Oops, I lost 813. Sorry, I lost 813. Anybody whose question was not yet answered, raise your hand. In the meantime, I'm back to 801. You can raise your hand by pressing *5. *5. Area code 801. Where are you calling from? 801. Area code 801. Where are you calling from?
Hello.
Yes. Hello. I can hear
Rajiv
you. I can hear you. Yes.
Okay. I'm calling from Salt Lake, Utah.
Okay.
My question is about H-1B unemployment days. So if I'm with my existing employer on a H-1B I-797, let's say this is the first one, and if I get employed with my new employer with a new H-1B, will my unemployment days from the existing employer carry forward to the new employer?
No.
Whenever
No.
H-1B
You get
approved, it's
you get a new 60-day period every time you change. Okay.
Okay.
All right.
Thank you.
Good luck. Area code 813. Where are you calling from? Area code 813. Area code 8.
Hello, Rajiv sir. Rupinder this side. I'm calling from.
Hello.
Hello.
Calling from where? Sorry, you lost.
Sir, you are able to hear me?
I lost one word there. You said I'm calling from. I didn't hear. Yeah. Hello.
Sir, are you able to hear me?
I think you're dropping words here and there. First of all, where are you calling from? Let's begin with that. Can't hear you, Rupinder. Can't hear you.
Your voice is breaking, sir.
Yeah,
Hello?
your voice is breaking
Hello?
for me. Not sure what's going on.
Am I audible now?
Yes, you are.
Okay. Hello, sir. My name is Rupinder. I'm calling from Tampa, Florida.
Go ahead.
I have a quick question regarding the 485 filing, which I have done last year in November 2020. Is there any way I can come to know what number or where we are on this to identify where my number is queued up?
You cannot. What else? Next question.
Okay. Next is I just wanted to know about if we switch the employer, do I need to file anything?
Yes.
Or refile everything?
If you switch after your I-140 is approved and your 485 stays pending for 180 days, you can move and file I-485 Supplement J. Okay?
Okay.
That's it.
And rest of the application will be...
Yeah, rest of it will continue. Just talk with your lawyers. Make sure that your jobs are same or similar. Okay.
Okay.
Good.
Okay.
Good luck,
right.
Rupinder.
Thank you so much.
Bye-bye. Okay. Bye. Area code 404. Where are you calling from?
Hi, Mr. Rajiv. This is regarding NVC letter. I line got disconnected.
Okay.
So, yeah. The question is like when I extended my H-1B, the I-94 number, one of the digit got jumbled. So I have a new I-94 number on my H-1B extension. Was that the reason I got the NVC letter?
No, that should not be the reason. No, sir. Okay.
Does it cause any overstay or anything?
No, I don't think so. I always want to correct the record. So what I told you holds. I don't see any danger for you. I think you're fine. Okay.
Okay. How can I correct that?
I already
Sorry,
told
how
you,
can I
sir.
correct the USCIS?
I gave you the whole spiel, sir.
Okay.
I told you first look at your I-140.
Okay, got it.
If you made the mistake, then just tell the NVC to withdraw. You're staying with the 485. If USCIS made the mistake, open a service ticket. Tell them, why did you start this? They should withdraw the NVC filing. Okay?
Sure. Thanks, Rajiv.
You're welcome. Area code 919. Where are you calling from? I think that's North Carolina. Go ahead, North Carolina.
Hi, Rajiv. Yes, North Carolina. I think earlier you pointed me to the page where the fee structure for applying for USPR is.
Yes.
I just wanted to double check that.
Right.
Is that the section where it says legal fee $3,600 to be paid at the commencement of the case, and then other fees?
I don't know which.
listed there in the box?
Let me go to our page. So if you go to our fees page, what are you trying to get done? Sorry, remind me.
So my wife is a US PR card holder, and I am going to apply for PR.
So you'll go to green card for spouse, children, parents of citizens, and green card holders the same amount. So that's the last one. And what does it say? Yeah, 3,600 exactly. That's the one. Okay.
Okay. 3,600, and the other fees are the form related fees
Right.
and stuff there.
Exactly. Exactly. Okay.
Thank
Good luck.
you, Rajiv.
You're welcome. Good luck. Area code 801, returning customer. What's up?
Thanks for taking my question again. It's regarding the H-1B first visa stamping. Are we eligible for Dropbox, the new rule that got passed?
Yeah. Did you come on F1? What status did you come on?
Yes, that's correct. I came on F1 visa that's stamped.
Have you had
right now my H-1B is
okay?
approved,
Have you had
but
any?
not stamped yet.
Have you had any other visa refused?
No.
Okay.
The F1 visa I applied for the first time and it got approved in the first
Yeah,
time.
you are eligible for interview waiver, and they have already implemented that. Somebody on LinkedIn showed me that they're already implemented it, and they have instructions on how to get a waiver. All right.
Yeah. Thank you.
You're welcome. Good luck. Okay, folks. I'm done with all the questions that were asked. If somebody just logged in and they still have a question, press *5 on your phone. I've got 7 or 8 minutes more. *5 if you have a follow-up question on any question. Okay, this one is from a private number. I don't know who they are. So go ahead, ask your question. I can hear you.
Hello.
Yes, I can hear you.
Hi. Thanks for taking my question. I'm on H-1B and my extension is coming up. Actually, my visa is going to expire in September. My employer is going to start extension in Feb. So currently I'm living in California and I'm planning to move a different state. So what is the best way to file the amendment? Can I go with the extension process while filing the extension? Can I go with the amendment, or have I planned to leave here till August and then I plan to move to a different state in September?
When does your current status expire? When does the current H1 expire?
September 2022.
Okay, yeah. So yeah, you should file for an amendment and extension in the same case. Okay.
If we file that, can I stay in California, or do I need to move to a different state?
Okay. So you are currently in California, right?
Yes, I am.
Yeah. So until the petition is approved, you're not required to move. Once it is approved, then you're required to move. Okay?
Oh, okay. Okay, thank you, sir.
Good luck. Okay, so area code 857. Where are you calling from? Last question of the day. Area code 857.
I'm calling from California.
Yes, go ahead, please.
So actually, my H1 got approved in the third lottery, and
like since it's a hybrid work situation, so I'm not planning to go back to my work location, which will be like Boston. So I'm not sure like till how long can I work from a different state, because in my LCA the home address is the Boston address and the work address is the same office address in Boston, but I just want to work from California for
You have to file. You should not have been working from. You should not work from California. You have to file an H-1B amendment. Otherwise, you're violating your status.
Okay, so is it better to go for the H-1B amendment later, because I still don't have a California address? I'm just visiting for a month or two, or I should get a address like as ASAP, and then just for the first petition in the LC only I can move to California and get the California address.
Where do you
is it
are you going to live in the same city where you are living right now temporarily?
Yeah.
Then just file with the current address, because if you stay within 50 miles of that, you don't have to file an amendment again.
I see. Okay.
All right.
Yeah, thank you.
You're welcome. Good luck.
Thank you.
You're welcome, ma'am. Folks, good talking to all of you. Wishing you again a very, very happy new year. And I will see you again in 2 weeks. It's always a pleasure to talk to you all. Be well, everyone.